Welcome. In this episode of Health and Wealth, I'm joined in the studio by Benjamin Hoffmann, who is a patent attorney with Potter Clarkson, one of Europe's largest IP law firms. And Benjamin, welcome. Nice to have you here.
Thank you.
Start by telling us a little bit about what Potter Clarkson does and what do you do there?
So we are intellectual property attorneys as a firm, and we provide all those legal services that are needed to effectively capture, register, and then exploit and leverage intellectual property for our clients.
And IP or intellectual property, what is it really? And why is it so crucial for life science companies?
Okay, that's a big question now. I'll try and break it down. If we think firstly about property is things that we own. And so we can have tangible property like buildings and lab equipment and so on. That's very easy to define. Intellectual property is effectively everything else. It's all these intangible things that a company might own, but they are a form of property. So we can register them and we can license and commercialize them going forward. And so when we break it down in a company, we can have know-how and trade secrets that we might keep internal. And then we can also have things like our branding and how we actually sell our products. And that might be registered via trademarks and other rights. And then we have effectively our intellectual creations, our inventions, which we might well register as patents going forward. If we look at, for example, a large company that's selling something like a mobile phone or a car, it's a very complex product with lots and lots of small concepts in it. Might be hundreds or even thousands of patent applications covering one product. And each of those patents and each of those small aspects represents a small amount of value, but it's quite hard to say where is the value in a car or where is the value in a mobile phone. If we go to the extreme end of life science companies, we have for example, a new therapeutic, and it's a very simple concept in comparison, for instance, to a mobile phone. It might just be a molecule, and we know that molecule has activity in treating a new condition. That is a very simple asset that's quite easy to copy, for instance. It might only be protected by one patent application. In the long run, that may be the entire value proposition of the company for a period. And it's going to take us a huge amount of money to bring that new therapeutic to the market. And we want exclusivity at the end of that process. And there can be periods in a drug's lifetime where you may have one patent which is representing almost the entirety of the protection around that particular therapeutic. And so that's the real barrier to entry for generics. And it's the ability for us to leverage a high price going forward. And so when we're looking at a life science company, and particularly those developing new therapeutics, the IP represents a huge amount of the core value proposition of a company. It can be both the registered patents, but also actually the internal knowledge of the company, all that R&D they've done, and what has worked, what hasn't worked, how they go about identifying new targets and how they go about developing drugs. All of that is important things to keep internal and have a proper IP strategy for managing. They're core aspects of the value proposition of a company. And we see it as really important for life science companies to understand where that value is, what it is, and how to actually protect and in due course leverage it going forward.
And equally important to investors then. I think many listeners might disagree, think that there's nothing in fact simple about antibodies or chemical compounds at all. But if we look at it from an investor's perspective, then IP obviously is important. Yet quite often when you see a company issue a press release, for example, about a new patent being granted in this or that market, quite often there is no real reaction to from the stock market, for example. The share price doesn't go up or only a little. And I wonder then, is that seeing as IP is so important, is that just ignorance on the market's behalf, or is it fair that nothing happens with the value?
I think there are a number of explanations for that. I just want to go back though and clarify that I don't think they're simple inventions. I don't mean to undermine or belittle life science companies. I can see you're smiling now. I think it's to characterize them, or ultimately possibly the ability to reverse engineer from a competitor perspective, and there's a certain amount of simplicity there that can be copied, and that creates the vulnerability that IP can protect for us. You asked about, we don't often see a strong reaction when there's, for example, a development in the IP portfolio like granting. There can be, it does happen occasionally, but I think a key reason behind that may be that the IP filing and granting process for patents in particular can often happen many years before we actually reach market. And it's not directly coupled to whether you're going to reach market or not. So much stronger signs of are you on the right track to get to market are, for example, clinical trial checkpoints and actual marketing authorization being granted in the key jurisdictions. That's when you can expect a strong reaction from the market, because that's a much more closely connected sign of the return on investment. I think, on the contrary, though, we do see the perceived value in IP when we look at the tail end of a drug as it's on the market. For instance, we can often look at drugs on the market and know where we call them patent cliffs, are going to arise. So we know when they're going to lose exclusivity due to their patents. And so we know in principle when generics may enter the market and challenge the value proposition that's there. And that can have a significant impact on the stock price of a company.
So if you have a projected sales, for example, that's really translatable into what type of money will you lose when you lose exclusivity?
It can do. Yeah. It can do, yeah. And we don't know for certain generics are going to come in, and we don't know what type of generics and what kind of competition they're going to present. There can be a certain amount of trust value from customers and doctors in therapeutics, for instance, of wanting to stay with the primary producer. But it is clear that when generics enter the market, they're going to have an impact on price and actual leverage of value from a primary asset. If, for instance, a patent is actually invalidated prior to its expiry, that can also have a significant impact on stock prices. And we do see, when there are patent challenges, for example, when litigation begins or there's a challenge in one of the primary markets to validity, just the initiation of that challenge can have an impact on market value. So really the correlation of the patent portfolio and the stock price is much more linked to the validity or perceived validity of that patent and the lifetime of that patent, more than whether it's granted or not in its early stages.
And you mentioned litigation. Is that a very common thing when it comes to particularly new drugs, for example, that patents get challenged by competitors, for example?
Yes, it is. If you're making a lot of money out of a drug and you've done all the work to get it to market, you've proved that it can get to market, there's always going to be people wanting to take a shortcut and copy you. Now, we know, for example, that clinical trials themselves provide a certain amount of data protection for a certain period. So there is an economic barrier to bringing to market. Generics might have to go through their own clinical trials, for instance. But when your data protection runs out, in principle, a patent may be the only barrier to market. So if there's a large market there, then generics are going to want to enter that market and maybe would want to challenge the validity of the patent to shorten their time, shorten their period that they can come into market and actually come in earlier.
So you mentioned data protection, and there's patents, and there's also other types of protection that you can get, like orphan drug designation. Can you give us just a brief walkthrough of basically the periods of length, or the length of periods of protection for the different types? And if there are many other subtypes that I don't know, you don't have to go through all of them, but just the basic ones, basically.
So it's easiest to start with a new therapeutic, and we can look at the patent portfolio of a new therapeutic. Typically, your first patent filing on the drug compound will be for the drug itself. If it's a newly developed compound or antibody or whatever it may be, there'll be a filing directed specifically to that antibody, effectively for use in all types of therapies. And then as it develops and goes through clinical trials and comes closer to market, we expect there to be challenges along the way that need to be resolved. For a compound, you've got to make it in a stable form that's shelf stable and able to perhaps tolerate the stomach and be delivered into the body. For instance, if it's an antibody or some kind of biologic, it often has to be formulated for injection. That process leads to secondary filings in the patent portfolio to do with perhaps crystal forms or formulation types. Also, we might observe that there are certain other indications that it can be used for. We might primarily have a use for a certain type of cancer. There may be subpopulations in the cancer group where we have specific efficacy, for example, or there might be a co-formulant that comes in that increases efficacy. And so we can see patent filings related to those sort of secondary developments. And typically the timeline there might be you'll have your primary therapeutic would be, say, at day 1, and then it might be at year 5 to year 10, as you're going through clinical trials and getting to market, you'll develop those follow-up portfolios. When we actually get marketing approval, we get the 10-year data exclusivity in Europe. It can be extended by a certain number of months, depending on whether you're looking at, for example, pediatrics trials or whether you're looking at orphan drug designations and things. There's lots of rules about how much it's extended for in whichever scenarios. Separately, as soon as a drug is marketed, you're entitled to a maximum of 15 years patent protection for your primary therapeutic, for the first one to bring it to market. I say that with some kind of caveat. I just want to clarify. A patent is usually 20 years from its filing date to its expiry date. So if we're filing on day 1, we might not get our drug onto market until year 10. And so it seems that we only have 10 years of exclusivity there from the patents. But there is a way in a number of jurisdictions, Europe and the US are two key ones where we can do this. We can extend that patent term protection on the primary filing for a total of 15 years in Europe and 14 years in the US, I believe. We do that by effectively taking our marketing approval when the drug goes onto the market and linking that to one of the patent filings that covers the drug and applying for extra protection. So in combination, this sort of primary filing, which is quite often extended to get this up to 15 years in Europe, as well as all these secondary filings on the formulation and so on, provide this very clearly defined timeline of when exclusivities are present. And you can tie that into when the data exclusivity from the clinical trials is expected to run to. And you can define your checkpoints of the data exclusivity is a very good barrier because it's an economic barrier. You can't litigate through that. It's an economic barrier that's going to stop companies coming in. But in principle, once that exclusivity runs out, they can benefit from your data and get a shortcut to market. So we like to see a patent term extending beyond that. And we want to map out what is the patent or what patents provide that extension beyond the data exclusivity, ultimately. The timelines here can be quite varied depending on if you're quick to market or if you're slow to market. But what we like to see as patent attorneys when we're sort of evaluating this patent cliff is understanding where these various checkpoints occur and when that primary protection on the primary compound or the primary therapeutic runs out, and when we have protection on, for instance, formulations and so on, and when they run out. I think we shouldn't underestimate the value in that sort of secondary portfolio, as it were, because it may be there may only be one way to formulate something to bring it to market, for instance, in which case your formulation filing might have a significant amount of value. Typically, that might be filed 8 years after your first filing, could extend beyond your primary patent protection and provide a very useful barrier because it might be extremely difficult to formulate it to bring it to market. Or the formulation may, for instance, be closely linked to what was approved during trials. And so generics coming in would have to do their own set of clinical trials on a different formulation, for instance. And so that can provide a very useful barrier. They are secondary to that primary therapeutic patent filing, but they can provide significant value beyond that sort of first patent cliff. I think the interplay between all these different filings and what they actually cover and when they expire really tells us what value we think we can extract from the late stage marketing of our drug. So we really should be able to map out. We expect to be able to get the drug onto market in, say, 2029, and we know that in 2038 our primary patent is going to expire, and we may be able to extend protection to early 2040s, and then we're expecting, perhaps 2043 our formulation patent to run out. You can really map out a timeline of when these exclusivities fall away, and consequently when you think challenges from generics may occur and when the value proposition is really lowered, shall we say, for these therapeutics as they're on the market.
So it's clear to me that if you are say average investor, if you're not specifically specialized in life science, it all seems quite complex. And to keep track of, like you say, the different timelines and filings and so on, how do you as an investor, how do you conduct the necessary due diligence to have a basic grasp of whether a company is actually well protected or not, if you don't have the special knowledge that you guys at Potter Clarkson have?
What type of investor are we talking about here?
Well, say the average retail investor, for example, that could be very interested in life science and likes to support drug development for different reasons, or just seeing the potential of great financial returns when the drug reaches market, but necessarily not a patent expert.
For your retail investor, I think all of the discussions I've gone into are probably far beyond what I'd expect people to dig into ultimately before deciding whether to buy some shares in a particular company. But what I would hope is that if it was of concern to you and you wanted an understanding of what this might look like, a lot of this should be reflected in the quarterly reports from companies. Normally early stage companies, for instance, if they don't have an asset on the market, should be reporting where they are in their clinical trials. They should be reporting how things are progressing. I would hope as well they should be reporting an aspect of those quarterly reports should clarify their IP position, particularly on the patent filings. I think they should, early stage companies should celebrate when they get a patent filing that covers one of their primary assets, given the value that it may deliver in the long term. So from that retail investor viewpoint, it should be possible to look at quarterly reports and actually understand, is this company actually reporting on its IP and valuing its IP as part of its sort of overall value proposition in the long run. So that's a really good place to start. If you want to dig a little bit deeper, you can actually find the granted patents relatively easily, and to an extent you can actually understand how those granted patents may relate to what's happening. So we see different values being sort of afforded by a granted patent. Very crudely speaking, we can have a patent to a product, a use of a product, or a process. For example, a process of making something. So if a company is reporting, we've now got a patent for our primary compound, with relatively little effort on publicly available databases, you can go and find that patent that they're referring to. They should report the filing number, for example, of the patent. You can find the patent and just read claim 1 and see whether it's related to a compound, the use of a compound, or a process. If it's related to a process of making the compound, it's going to deliver a lot less long-term value than the compound itself. And if the company's reporting and celebrating they've got this patent, and actually the patent, when you read it, doesn't actually deliver that long-term value, that would be a little bit of a concern for me. But if it's clearly relating to the compound per se, I think that's a really good way to do some very light due diligence from the retail investor viewpoint, just the overall communications of the company about the value of their IP and connecting that to their sort of long-term business offering, as it were. Secondary to that, I think some heavy internet searching, you may be able to find industry reports or comments on particularly larger companies. I'm thinking of more blue chip pharma companies where they have assets on the market and they've got there's often talk of, for example, a pipeline. And you can have companies where you may be able to determine how much of their revenue generation is coming from a particular drug. And if substantially all of their revenue is being generated by a particular drug, and there's a patent cliff that's happening in 2025 or 2026, and their pipeline looks weak, that would be a concern for me for a long-term investment.
Then it's time to start thinking about exit.
Yeah, yes, yeah. So you can, from that sort of early stage company, you can do some light due diligence and work out how are they actually reporting their IP. From the larger companies, there should be a lot of commentary about the status of that company, where they're actually generating their revenue. If they're generating their revenue from multiple assets in multiple different markets, a single patent cliff is not going to be overly impactful on their overall revenue generation. If they're talking about a healthy pipeline as well, then I'd have a lot less concerns about the sort of value proposition by that investment.
And you mentioned a number of different different patents that patent on the compound, patent on the formulation, or the use. How would you grade those or rate those in terms of value creation?
So the most valuable patent is the patent on the compound, because that, if it's valid, there's a big if there, but if it's valid and it covers the compound, then it provides universal protection against anyone using that compound for any particular therapeutic use. So that's the most valuable. The next most valuable, I would say, is possibly a use of a compound. I say that with some hesitancy because it's not usually written as use of compound for this. It's usually compound for use in this. If you have, for example, a compound for use in treating condition A, then that only provides you exclusivity for that use. Now, if it's brought to market and that aligns with the marketing approval, that's good protection. But in principle, someone could actually develop and sell a compound for condition B, and they'll be free to do so outside of that first patent filing. So that sort of use claim, as we'd call it, is valuable, but it has less overarching and encompassing value than that pure compound claim.
It's not as universal.
Exactly. When we talk about the other types of claims, a formulation claim, well, that's only the value is really dictated by how easy is it to reformulate it in another way. And that's a very difficult question to answer unless you sort of dig into the specifics. In terms of methods of making, that's an interesting one, because with some materials, some biological materials, for example, they can be incredibly useful claims. But by and large, if someone figures out a different way of making it, then then
you're screwed.
Yeah,
basically.
Yeah, you are. Then they can circumvent the patent. And often the protection by a process claim only covers the direct product of that process. And very often, if it's made out of jurisdiction, particularly if it's made by a different process, there's no actual reach-through protection for the product per se in those circumstances. So there really are much narrower protection that can have use in certain biological environments, but overall it's less certainty in the value that actually provides.
So you could say that there are levels of protection, levels of value creation linked to that, different types of protection. But what should you as an investor be looking out for in terms of bad signs or red flags? I mean, what would you look for to see if this is a deal breaker, for example?
So I think that the type of due diligence where we usually dig into this in a lot of detail is if we're looking at the the institutional investors that are coming in with significance, Series A, B, C, that level of investment. Also, if we're dealing with, for example, corporate clients that might want to either acquire a small company or license in a portfolio.
We're talking deals in the tens to hundreds or even billions.
Yes, yeah, and that kind of level, certainly anything above about perhaps above about 50 million SEK would be a sort of ballpark figure where we'd expect to see significant IP due diligence. And very typically, we would want to apportion about 1% of the deal value to IP due diligence as a sort of rough rule of thumb. We really want to understand how certainly the patent portfolio maps onto the drug that's going to be on the market, and where those patent cliffs are, and the actual strength of any patent claim through that patent cliff process, as it were, through the sort of various stages of it. So I mentioned, for example, the ability to extend patent filings by up to 5 years to get this sort of maximum of 15 years. But that extension process is not straightforward. In principle, it's very simple procedural law. You just have a patent claim, you have marketing authorization, you file the sort of two together, and then you get granted it. But there can be a lot of scenarios where there's nuance to it. A very simple scenario to sort of point out is if you're actually dealing with a combination of A and B, which are administered together. Do you use a patent claim on A? Do you use a patent claim on B? Do you use a patent claim on both? What happens if they're both? What happens if they're administered separately? One's every day, one's once a week. How does that actually look for the patent claims? And how do you actually get the extension from that? And can you get the extension from that? And understanding what scenarios you can get that extension and what scenarios you can't get that extension becomes very, very important. And really, when we're looking at these much more high value deals, we would want to understand the likelihood of us having patent protection in year 2030, 2035, and so on, the likelihood of us being able to get those extensions. It's all to do with sort of risk that's involved here. Are we very certain that we can extend it, or is there a risk? Do we know of precedents where that type of compound has not been protectable via one of these extensions, or this type of therapy is not being protectable, for instance? And so where we would usually come in is overall to map on the long-term proposition of this patent portfolio and understand the risks involved. I think certainly for smaller pharma companies, and particularly at that earlier stage of investment, a very important part of due diligence is us understanding what we often call provenance of the invention.
What's that mean?
So this is going from an invention always has an inventor, and that's a person. So that person has created the intellectual property, and somehow a patent has been filed by a company. And we need to understand how the invention got from that person to the company. And it could well be, particularly with early stage companies we see that are spun out from universities, it could well be that there's a university involved. And there's been a transfer from the professor to the university, and then the university to the company. Or there might well be multiple people. We see this quite a lot when there's clearly an evidence of 2 or 3 years of R&D before a company has been formed, and all of a sudden a company's been formed. Well, what happened along the way there? Have we actually captured all of the inventors along the way? Because there's no good naming 3 out of 4, because you can guarantee in 10 years' time, when you've got $1 billion drug on the market, that 4th inventor is going to pop up and say, hey, I invented this. I want a quarter of the money, please. And so actually understanding who should be named inventors, whether they're properly named inventors, and whether those rights have gone through the right chain of transfer to the ultimate owner of the patent application or patent, whether there's an owner or whether there's licensees involved, whether there's a university involved, or whether it's an individual that's involved. In Sweden, I'm sure you're aware that the professors actually hold the IP. And so often there's individuals involved. Were they named as the patent applicants, or did they transfer it somewhere? If so, was that done before or after they filed, and was the paperwork signed properly? A lot of times people can agree to things when there's no value involved, and disagreements arrive when there's value on the table. And so we need to see a very clear chain of transfer from those inventors to the company and make sure all that paperwork is tidied up, so we know that 5-10 years down the line, we can then pass this portfolio over to our exit investment or to our corporate investor that might be coming in, who we can just present them with a schedule of here's all the inventors, how they transferred all the rights, and the assets are all in place and ready for you to license or ready for you to acquire.
It just struck me that you hear about VCs, for example, VC funds. They have the deal flow is that they get proposals, like hundreds or even thousands of proposals from companies who would like them to invest. Yet they only invest in a fraction. For obvious reasons, maybe the money is one limit. But how often do you think that the patent situation is the culprit, so to speak, a deal breaker? I mean, it's definitely difficult to guess. I realize that. But would you say that it's a common problem, this?
I think when we look at corporate investors, so blue chip pharma companies.
Like a big pharma company, yeah.
They know, I think they have a very good understanding of the value proposition of a patent portfolio and IP in general. So the trade secrets and the know-how and the R&D that they're going to acquire, they understand the importance of registering that properly and the value there. And so I think for those types of investments and deals, very often IP can be a deal breaker, because they'll see that, yes, they can take this to market, and yes, they can get it through clinical trials. They give it to their medicinal team. Confidence level there is high, but they can only see 2 years of exclusivity at the end. And the value is just not delivered on that, or they're just reliant solely on data exclusivity, for instance, and the value might not be there for that. So there may well be a lot more deal breakers in that corporate scenario if there's not a high level of confidence that you can get that strong and long patent cliff. I think with VC investments, our general impression is it's perhaps an aspect of due diligence, but it's not as thoroughly investigated. I don't know what the reason is for that, possibly the complexity of investigating it in comparison to VCs often have in-house medicinal staff that can very well interrogate clinical trial information or therapeutic information, and they can do good due diligence on that, and they can interview and meet the scientists and have confidence in the team on delivering. They might not have in-house legal expertise. And it's quite often an aspect of due diligence, but perhaps it's just a checkbox aspect instead of the thoroughness that we often see at the corporate level.
And, you mentioned then that in the due diligence process, when it comes to the bigger pharma companies or even VCs, then they should allocate about 1% of the deal value. But for a company, then for a smaller company, for example, what type of costs are involved with managing their IP portfolio, for example?
Managing the IP portfolio I think, should be something that's properly budgeted for. And the good news is it can be properly budgeted for. Very typically, we can predict the costs of drafting and filing a patent application, approximately getting it through to grant, the timescale of that, and then the ongoing costs of keeping it in force. And so it should be possible for any given invention to sort of plan out almost a 20-year budget of what that's going to be. And it's very much easier to plan out a sort of 12 to 24-month budget. And then as things progress, you can update that as we go along. In terms of, just putting some rough numbers on it, for instance, if you wanted rough numbers, we would typically budget somewhere in the region, shall we say, of around about 100,000 SEK to draft a new patent application. That's a reasonably healthy budget. On a more complex filing, it might be 150,000 SEK or so. The actual filing fees for the first filings are relatively low. If we don't update the application, we then get some more significant filing fees coming in at around about the 2.5-year period. The reason is we typically go through a process where we file what's called a PCT application at some point, and that means we can basically delay the filing in all these different countries. So a patent application is country specific. That's where the significant costs can come, because we might have then to pursue patent applications in all of our key markets: Europe, US, Japan, China, Korea, Australia, Canada, Mexico, name the countries with big populations and well-functioning healthcare systems. That's where we'd be interested in. That can very easily spiral into 20, 30, 40, 50 countries, each one attracting fees of, say, 30 to 50,000 SEK just to file it in those countries. We have to engage with local attorneys and so on. So you can see that I've mapped out 150,000 to get it on file, perhaps 50,000 after year one to get this PCT filed, SEK. But then at year 2.5, if you're ambitious, you might be scaling to filing fees which are up 1 to 2 million krona. And then we have ongoing prosecution costs of perhaps 50,000 SEK every 18 months in each of those countries to get it through to grant. That's for one patent filing. If we're going to have multiple patent filings, obviously we need to balance our overall budget and the number of countries we're interested in and the value that that patent's going to deliver for us in the long term. So it's important to understand what the overall budget is of the company and understand the ultimate value that's delivered by IP in the long run, and apportioning the appropriate amount of resources to funding that IP. And earlier on, we were discussing the value ultimately in that sort of first filing, in that core therapeutic filing. A failure we often see in patent portfolios from a sort of ultimate long-term investor viewpoint is poor resources are allocated to that first filing. This is very, very common in startups. You typically don't have much money at that early stage, so you might not have the luxury of 150,000 krona to get that first filing right, to get deep engagement with your patent attorney drafting it. You might not get very good correlation between your patent application and what you actually need to protect. Data might be quite thin on the ground as well. It's all sort of put together in a rather hastily way and doesn't actually line up and hasn't got the thoroughness needed to make a robust patent filing. And then at that 2.5-year stage, when you have that, I mentioned 2-3 million krona budget we'd like to have, you might only have 200,000 krona. That will get you to go ahead and say the US, Europe and perhaps Japan. That's looking quite weak on the ground when you are then at year 10 close to market and you're excitedly bringing in a corporate investor and they're looking at it thinking, well, we've only got exclusivity in US and Europe, but we want to take this drug to market in
globally
50, 80, 100 countries. You know, we see with big patent filers like GSK or Novo Nordisk or so on, core lead compounds, they may be filing in 150, 180 countries because they know in the long run they're going to want patent protection in all these places. And that will be a primary inspection point of when they're looking at a target and acquiring a small company. Where globally does this patent portfolio extend? And it's very common to see it just in US and Europe for that very early filing for very understandable budget reasons.
Yeah, I mean, it must be a tough balance for smaller companies to know how much gunpowder should they use then on these filings. But I know that, and you mentioned that Potter Clarkson, you work with some of the biggest life science companies in the Nordics, like Novo Nordisk and Lundbeck. Do you also help the smaller companies or perhaps even investors with if they need a help with IP?
We do, yes. So we work with all types of companies on the life science area, as it were. So you mentioned Novo Nordisk and Lundbeck, who are two long-standing clients of ours. It's public record we work for them, and we typically are doing quite specialist work for them that's outsourced, filling a niche that they would rather have us do than them handle themselves internally. One has to recognise that Novo Nordisk, for instance, has a team of 20 or so patent attorneys, just like me, that are handling everything internally, and they bring Potter Clarkson in when they need specialist support in a certain area. On the other hand, when we look at the earlier end of the spectrum, our clients in that area, we work with quite a number of clients in the Nordics in this area, taking them from sort of day one all the way up to drugs on the market and through litigation. Some very long-standing relations there. We are effectively trying to be that in-house team that Novo Nordisk provides. So we engage very closely with our clients and try and get that value for money at that early stage, and then deliver on them actually capturing the value out their IP. And the value or service offering we like to have at Potter Clarkson is that we say full service in IP. So once registered, we're able to help our clients through the licensing process and through the enforcement process, if needed, to actually leverage IP going forward once it's actually been registered. With some of our smaller clients, small and medium-sized clients in life sciences, we really try and support them as best we can through that sort of growth cycle, as it were, from those early stages all the way through. We've sit on a number of the boards of our companies, providing input to IP and sort of the overall company strategy. And that's valued, I think, by the clients where we actually have that level of interaction. On the investor side, it is something where we do have good relations as well. We've worked with a number of VC funds in the life sciences, ultimately trying to help deliver clarification of the IP portfolio and the value it's capturing, and the IP strategy of the company, and how that may actually sit in the long-term picture of that investment. And I think really for those larger investments, we're talking in the sort of 100 million plus SEK range. I view it personally as a vital part of due diligence, because if your investment strategy is to take it up to phase 2 and then deliver it to a corporate investor or perhaps a next series investor, at some point someone is going to want to really, really get to the bottom of the value of that patent portfolio, and can it be, what does that patent cliff look like? And so the earlier we can actually get an understanding of that, and the earlier we can sort out some of those issues with provenance and transfer of rights that are highlighted, the earlier that we can get in and clean up things, it's much easier to resolve at that early stage than at a later stage. So we getting in there and evaluating how things stand, and then potentially for those investors delivering a roadmap of, well, this is what we would recommend going forward. This is areas that could be improved, and this is action points that can be taken post-investment. I think that's seen as quite helpful for the clients we work with in that area.
And it sure sounds to me like a sound investment for the future.
Yeah.
So, thank you very much for joining us today and clarifying all the bits and pieces around IP. Such a complex yet very interesting subject. Thank you very much for your time.
Thank you for having me, Jonas.